breaking down the entire South Carolina probate process step by step. Exactly what happens from the moment someone passes away until the estate is closed. Whether you're a surviving spouse, executor, or heir, this is a roadmap that every family needs. We'll cover the normal timeline, the small estate shortcut, and some key deadlines that you can't miss. And there's also some information at the end pertaining to real estate that you want to know about. Quick disclaimer, this is for educational purposes only. This is not legal advice. Every state is different. Please consult with an attorney licensed in South Carolina for all your probate needs. Results vary. All right, let's get to it. So, why probate matters in South Carolina? Probate ultimately is the court-supervised process that validates a will, if any, pays debts, and transfers assets to the rightful heirs or beneficiaries. An important note here, the primary function of probate is to give creditors one last bite at the apple. It is not the distribution of assets to the rightful heirs. That is secondary to the creditors getting paid. A point in fact that you can't close the estate until every single creditor has signed off that their claim has been satisfied or they waive it. In South Carolina, most estates use informal probate. It's faster and simpler, and when there's no conflict, if someone's not contesting the validity of a will or paternity is not a question or anything along those lines. So, typical timeline, a minimum of 8 months, although it usually ends up being closer to 12 for a straightforward estate. Small estates, which is under $45,000 in personal property only, can skip most of these steps entirely. There's usually a shortened process where you can just fill out a couple forms, file with the court, and you're good to go. All right, so step one, gather documents. So you'll get a certified death certificate from the county or the county coroner's office. The original will, copy will not do. You need the original will and a list of assets, debts, heirs, and beneficiaries. Pro tip, the person in possession of the will must deliver it to the court within 30 days of learning of the death. That's important in South Carolina because if the will is not filed within 30 days after death, there's a good chance that the estate will proceed under intestacy statutes, not the will. So, step two, file the petition. You can go to the court in the county where the decedent lived or where the real estate is located. You're going to use Form 300 ES. Very handy online. If you search for South Carolina Probate Form 300 ES, it's one of the top results. And then you want to select the option for informal probate, means no hearings if there are no objections. Step three, appointment of the personal representative. The court appoints the executor who is named in the will or administrator, which is what we call the person if there is no will. You receive official letters stamped by the court giving you legal authority to act on behalf of the decedent and the estate. Usually it happens within 1 to 3 weeks of filing, depending on the speed at which that probate court moves and how busy they are. Obviously, in some of the larger counties, Greenville, Richland, Horry, and around Charleston, they're going to be a little busier than some of the more rural counties in South Carolina. Step four, notify heirs and creditors within 30 days of appointment. So you're going to send formal notice to all heirs and devisees, and again, there's another form for this. That form is Form 305 ES. And you're going to publish notice to creditors in a local newspaper. It has to run once a week for 3 weeks. Creditors have 8 months from first publication or 1 year from the date of death, whichever is sooner to file the claims. If the claims are not filed in that window, essentially, if the claim is not filed within 1 year of the date of the death, that claim is barred. Step five, file a detailed inventory. Again, back to a Form 350 ES of everything the decedent owned at death. You probably need to get, if there's real estate and vehicles involved, you may need to get appraisals done. Sometimes tax value works as well. And then step six, this is what goes on. This is what I call the hurry up and wait phase. Essentially, after you've done notice to creditors, you're going to be sitting around for a few months. You're going to open an estate bank account. You'll have to get an EIN from the IRS. Again, you can do that online easily enough. Pay valid debts, taxes, and expenses. One thing our firm does is to deny creditor claims if they're not properly documented. For example, let's say the decedent had a credit card and the credit card company filed a claim for $15,000. We'll initially deny it and claim that they haven't satisfied. They just sent in a form essentially said decedent had $15,000 in credit card debt. We actually forced them to prove that the purchases were valid, that the card was used in an authorized manner, wasn't fraudulent. And sometimes they drop the claim as opposed to going through all that work. And then, and this is ongoing as well, collecting any income or sell assets if needed. And probably one of the more important things is to maintain the estate, particularly if there's real estate involved. Pay the mortgage, pay taxes, make sure the utilities stay on so that the property doesn't go into disrepair. And then finally, we're getting to the end of the process here. File a final accounting. Once all debts are paid and the creditor period ends, there's a complete accounting, Form 361 ES, showing every dollar that came into the estate and every dollar that went out. Important note here that if there is no conflict of the heirs, or say there's a sole heir, there's another form, I don't have the number in front of me, that waives all the final accounting and reporting requirements. It makes it much easier to close out the estate. But if you have to jump through those hoops, file the final accounting and then proposed distribution, and go through that process, the court will approve the final accounting, assets are distributed per the will, and the estate is officially closed, and you'll get a letter from the court saying that you are relieved of your duties as personal representative or administrator. So, small estate shortcut and a few other tips here when it comes to South Carolina probate before we end our case study session today. One, start early. Delays cost money and create family stress. One thing we see a lot is that families let property just sit for years, or even generations. We had one consult the other day where the original owner passed away in the 1950s and nothing had been updated. And so now we're dealing with great-grandchildren and multiple estates. It just, quite frankly, it becomes very expensive. It was like a piece of property that's worth $20,000, and they're easily looking at least that much in legal fees in order to clean it up. So keep excellent records from day one. Any expense you pay out on a part of the estate, make sure you keep a receipt of it, and you know how much money is going in and going out. And informal probate really is the goal. Avoid formal and contested proceedings simply because it's a huge expense and it makes it take a lot longer. And then one final note on real estate. If there is no will, or if the will does not explicitly say that the personal representative can sell the real estate, you're going to have to get court permission to do that. This is just another step in the process. It's going to add time and expense. So know that if you have an intestate estate, meaning that there is no will, and you're looking to sell real estate, most likely you will have to get court permission. Now, there's an exception to that. If the decedent has been, the date of death is more than a year past, then there's a shortcut. But most likely, if no will, then you have to get court permission to sell the real estate. So that is the complete South Carolina probate process for 2026, from filing to final distribution. If you've recently lost a loved one or named executor or having an heir waiting on an estate, drop your biggest question and I'll do my best to answer it right now or in a follow-up. Ready to get your own estate moving? Please reach out to us. And then really, if you want to avoid the probate process entirely, and a lot of people after listening to all this, the paperwork and steps that go through, or actually having experienced the probate process, want to avoid it, look at using a living trust as the basis of your estate plan. Anything in the trust bypasses the probate process, and so you're able to resolve things a lot quicker. So next, we'll be back with another case study. Hit follow, subscribe across every platform so you don't miss it. And final reminder, this is for educational purposes only. This is not legal advice. Contact a licensed South Carolina probate attorney for your specific situation. We have several South Carolina attorneys that do probate, so we'd be happy to help you out. Thanks for joining us. This has been Bobby Sawyer. Have a great day. We'll see you.